The world of trademarks is inherently conflict ridden. People start new businesses every day, they adopt and start using new trademarks every day, and many of them go on to apply to register these trademarks with the United States Patent and Trademark Office or USPTO. And there is a pretty good chance that over the course of your business journey, one or more of these trademarks will come too close to yours in a way that could possibly confuse your customers and clients, creating a trademark conflict. One of the easiest and most cost-effective ways to end one of these conflicts is to send a cease and desist letter. Here's what you should know about them. Hey friends, welcome back to my YouTube channel. I'm Faith Minton, an attorney on a mission to simplify brand protection for entrepreneurs and business owners. On this channel, you will find tons of easy to understand, practical content to help you get a better sense for how to protect yourself and how to stay on the right side of the law when it comes to trademarks. And today, let's talk about cease and desist letters, a key weapon in the arsenal of every trademark owner. Whether you're a brand owner looking to enforce your trademark rights or you're someone who has received one of these letters, it's important to understand what they mean and how to handle them effectively. As a brand owner or trademark owner, it is your responsibility to monitor your trademarks to detect and address infringement. And this involves keeping an eye on the marketplace and your competitors to check whether anyone is developing trademarks that are confusingly similar to yours. On the flip side, if you are someone who is adopting a trademark, you have to make sure that your trademark does not conflict with anyone's existing rights. If there is a conflict, you may receive a cease and desist letter from someone claiming that you are engaging in trademark infringement. Trademark infringement is a large topic that I have talked about in another video that I will link to in the description and tag here. If you're unfamiliar with what trademark infringement is, you may want to pause this video and then go ahead and watch that one so that you have some context for what I'm saying here. But back to the topic of this video, what is a cease and desist letter? Well, it is a written notification from the sender to the recipient that the recipient is infringing upon the sender's trademark rights in some way. But beyond just being a notification, its purpose is to stop the infringement. Typically, a cease and desist letter will lay out a few very important things. First, it will identify the trademark in question as well as the owner of the trademark being the sender. And it will describe how the recipient's behavior is infringing upon the sender's trademark rights. More specifically, it may include details about any trademark registrations, information about when the sender began using the trademark, what the sender uses the trademark for, and how the recipient of the letter is infringing upon the sender's trademark right. Whether you are sending or receiving the letter, these facts are crucial for you to understand. Next, the letter will usually contain a demand to stop the infringement. For trademark owners who are sending these types of letters, it's important to be very clear about what you want the recipient to stop doing. For example, if you want them to stop selling a certain product line because it comes too close to your trademark, you have to specify that. Or if you expect them to rebrand their entire business altogether, you need to specify that. But if you're receiving one of these types of letters, you will carefully want to examine what this demand is to see whether it's something that you will actually want to comply with. You need to understand the impact of this demand on your business and the cost associated with compliance. For example, what would it cost you to shut down production of a whole new line of products you just launched, or to have to rebrand your company and change your product packaging, your store signage, your social media handles, your websites, etc. And then finally, the letter should explain what will happen if the demand is not met within a certain time frame. If you're the sender of a cease and desist letter, you want to give the recipient a definite deadline to meet in terms of stopping the infringement of your brand. And if you are the recipient of a cease and desist letter, you want to closely monitor this date to see whether you actually can comply by that date. And if there is a short window to comply, you may need to take action very quickly to assess whether the trademark rights being presented in this letter are valid and whether there is an actually valid claim against you for trademark infringement. Now, if you are a trademark owner trying to decide whether to send a cease and desist letter, timing is very important. You do not want to send one of these letters prematurely before you, or preferably your attorney, have had an opportunity to investigate the facts and determine whether trademark infringement has actually occurred. Because there may be cases where trademarks look alike and sound alike or have similar meanings, but they're used for totally different, unrelated products and services, so there really isn't a chance for infringement to have occurred. For example, let's say that you own a trademark registration for a software company, but then you find out there's a bakery 2 states away that's using the exact same trademark. In a case like this, it's not very likely that people are going to confuse a software company with a bakery, so sending a cease and desist letter to the bakery probably wouldn't make a bunch of sense and might actually backfire on you in the way of negative publicity. But another and more important reason why you shouldn't just rush off to send cease and desist letters is because you may find out that the trademark owner that you want to stop infringing upon your brand actually has stronger rights than you. That might be the case if their use of the trademark predates your use of the trademark. And if it is the case, they can respond very aggressively by sending you a cease and desist letter or taking other legal action against you, such as canceling your trademark registration, filing a trademark infringement suit against you, filing another suit to get a declaratory judgment about who actually owns the trademark, and much more. They can make your life really awful. So if you send a cease and desist letter without doing the appropriate due diligence, you may end up in a worse position than when you started. This is why it is crucial to have a knowledgeable trademark attorney assess your situation before you do anything. Because if you don't, you can end up shooting yourself in the foot. But if you are the one receiving a cease and desist letter from somebody else, it's important to weigh your options carefully and not just respond emotionally. Don't immediately stop using your trademark or assume that you have to comply with the letter without doing further investigation. Because sometimes people send these letters without having any legal basis to do so. But ignoring the letter isn't an option either, because doing that can result in some really terrible negative legal consequences. And so here's what you should do instead. First, evaluate the claims. Read the letter carefully to figure out what it is you're being accused of. Check whether the facts in the letter about your business are accurate, because sometimes senders get these things wrong. Next, consult a trademark attorney immediately. A trademark attorney can help you assess the strength of the claims in the letter and determine whether you are actually committing trademark infringement, because you need to understand whether these claims have merit before you do anything. Then consider negotiation. In some cases, cease and desist letters are just the start of a conversation between two brands. You might be able to find a workable compromise that keeps both brand owners happy. But you should also prepare for potential negative outcomes. If you decide to push back against the letter, be prepared for what comes next. The brand owner might reject your offer of a compromise, which is their right to do if they actually do have stronger trademark rights than you. And if you want to push back further, any further action may involve some type of litigation or court time. And time in court is always very expensive, so keep that in mind. Whether you are sending or receiving a cease and desist letter, follow-up action is always important. As a sender, you must be prepared to continue to enforce your trademark rights if the recipient doesn't comply with your demand to stop the infringement. This could mean filing a lawsuit or taking other legal action to protect your brand. And as a recipient of a cease and desist letter, if you don't respond or continue using the trademark as if you never got a letter in the first place, you might be leaving yourself vulnerable to terrible consequences, as I mentioned earlier. On either side, doing nothing can weaken your position. If you are the sender of a cease and desist letter, but you don't do anything after your stated deadline to stop infringement occurs, and the recipient doesn't comply with your demand and continues doing whatever they were doing before, and then you don't do anything about it, the recipient can claim that you basically gave them permission to continue doing whatever they were doing by not stopping them. And this can lead to something known as trademark abandonment, where you lose your trademark rights because you didn't take action to stop infringement of your trademark. The idea being, if you don't care that other people are using your trademark, why should we? Trademark abandonment is one of the reasons why your trademark registration can be canceled, causing you to lose your trademark rights altogether. Not a good outcome. And if you are the one receiving a cease and desist letter, but you ignore it, that can create huge legal headaches for you, because then the sender can claim that you were willingly infringing upon their trademark. This type of willful infringement can result in very harsh legal penalties, including, but not limited to, having to pay higher damages in a trademark infringement lawsuit, or even the possibility of having to pay the attorney's fees for the other party whose trademark you infringed upon. Courts tend to take willful infringement very seriously, so willingly infringing upon a trademark can seriously hurt your chances of mounting a successful defense. And again, not a good outcome. But overall, cease and desist letters are intended to help stop trademark conflicts before they develop into costly litigation. Whether you are sending one or receiving one, it's a tool that requires careful handling. Consulting a trademark attorney is always the best course of action because this video just includes a summary of the kinds of things that you should consider when it comes to cease and desist letters. And because it is a summary, a lot has been left unsaid. So be sure to consult a licensed attorney about any cease and desist letters that are relevant to your business, whether you are sending one or whether you have received one. And that's a wrap. If you like this video, please give it a thumbs up so the algorithm can do its thing. Be sure to subscribe to the channel for more trademark content and turn on notifications so you never miss when I post a new video. If you have thoughts or questions to share, as always, please feel free to put those in the comments. I read and respond to each one personally, and I would love to hear from you. Thank you for watching, and stay tuned for the next video.